Reply, Mr. Malmo-Levine.
Well, I said at the onset of today that my purpose here was to try to shift the debate from whether the harms are trivial and significant to whether the harms are mitigatable and reducible. And apart from perhaps Mr. Conroy, I feel I have failed in that task. Nobody here has asked me any questions about harm reduction, either to verify their existence or to challenge their existence. And
perhaps we're all convinced.
Oh, I hope so. I really do. Mr. Frankel, though, has a responsibility, and that is he should not mischaracterize my argument as there's not enough harm. It's not a matter of enough or amount of harm. It's whether the harms are inherent or whether they are mitigatable. And that applies to those vulnerable groups as well. I think Mr. Conroy made an error when he said I would prohibit these groups from my club. I wouldn't, and I didn't. I suggest that the vulnerable groups, the chronic users, the mentally ill, the pregnant mothers, and the immature youth, are the ones that need harm reduction the most. They need to be protected by the black market harms more than any other people. And we can address all the concerns that you might have about these vulnerable groups through harm reduction strategies, harm reduction methods, and the evidence that you heard today. For example, I started smoking pot when I was 14. The black market was what threatened me. Getting knifed or meeting people who were selling other things, all that. The separation of the hard and soft drug. I'm sorry, do you have a question? Oh, sorry. The separation of the hard and soft drug market is what the Dutch claim is their glaring success. And that is the kinds of harms I wish to protect vulnerable groups, especially youths in Canada from. And I believe that a parental permission policy would address all the concerns that parents and police might have and would encourage dialogue and discussion between parents and youths, and the homework would get done, the lawns would be mowed if some sort of, and again, this could fall into Section 1. Or say the mentally ill. Now, it is my understanding that the schizophrenics and other people at the Compassion Club have discovered that with proper strain selection, specifically avoiding sativas and focusing mainly on indicas and hashish, they can avoid some of the unpleasant experiences that have been characterized as inherent with schizophrenics using cannabis. A lot of these studies and a lot of these evidence that they're basing this on is based on Marinol, which is just THC. And like I said, the sativas, which are mostly THC, tend to wing you out, make you a little bit flighty and not good for schizophrenia. But the indicas and the hashish are. And a lot of schizophrenics and a lot of other people who are using cannabis for mental health or mental illness are dependent upon cannabis. And if they're using it properly, there's no evidence of any harm to them. Or the pregnant mothers. Do you know that cannabis has been used for time immemorial for nausea, lack of appetite and sleep, relaxation and relaxation of the birth canal muscles so there's no tearing? And perhaps cannabis is the #1 medicine because of its lack of toxicity for pregnant mothers. So that should be considered. And I myself am a chronic user. I fall under the definition of chronic user found in the Senate, over a gram a day. But I think that the quality of the cannabis, the organics, or whether it's chemically fertilized or organically fertilized, and the dose levels, the setting, these are all factors that differentiate chronic abuse from just chronic use. Like, say, a chronic caffeine user might properly use coffee but use it every day. And all these things that they blame cannabis for, point their fingers, say cannabis harms, would be this true for coffee if it was made suddenly illegal. If it was dealt by dark-skinned people 100 years ago, perhaps it would be illegal today. Because really, that's the only thing I can see that the opiates in cannabis and coca have in common. Not that they were more dangerous than the pharmaceuticals or tobacco or alcohol 100 years ago. They were distributed by dark-skinned people, and there is some evidence of racism in the creation of the laws. Now, Justice Curtis originally said, "Show us what you got," and we did, which was all harms are mitigatable, which is again found in the appeal book 106 and 186. But the lower court ignored this evidence by claiming there was no harm principle. The BC Court of Appeal ignored this evidence by claiming, well, you can't deal with dealing unless you first deal with using. So, again, I beg this court, don't invent excuses to ignore this huge pile of evidence on harm reduction. Incorporate the harm reduction evidence into your decisions on harm. And realize we're not, okay, I guess my time is up, but we're not asking, or at least this appellant is not asking, for the right of intoxication, or the right to smoke marijuana. No. This appellant is asking for the right to do any harmless activity. Any activity that the state has been given lots of opportunity to provide evidence of inherent harm and has failed year after year, decade after decade, generation after generation. That's what we're arguing for, the right to do any harmless activities.
Thank you.